The following video program is a presentation of the American Law Institute, American Bar Association Committee on Continuing Professional Education, a national provider of continuing legal education through courses, books, periodicals, audiovisual materials, and special projects to advance professional competence and responsibility.
The American Law Institute, American Bar Association Committee on Continuing Professional Education presents an Aliyaba Video Law Review Program, Employment and Discrimination Law under the new Supreme Court majority. The Court Turns Right. Introducing the program is Planning Co-Chairman Peter M. Panken of the law firm of Parker, Chapin, Flatow, and Klimpel in New York City.
Welcome to our program. We have a distinguished group of panelists here today. Before we start, I'd like to thank one of the most distinguished people whose idea this program was, Mr. Saul Schreiber, who was unable to join us. My co-chair today is Professor Leon Friedman of the Hofstra University Law School. We will have with us today people who are academic, Professor Friedman, some who are neutral, and most of the practicing lawyers here fall on one side of the fence or the other. Some of us are primarily employment lawyers for employers, others for employees. We have the neutral balance with the judges. Judge Marilyn Hall Patel of the United States District Court of the Northern District of California. I have good news and bad news with our next neutral. The bad news is Judge Ritchie is unable to be with us today. The good news is that the General Counsel of the Equal Employment Opportunity Commission, Charles Shanor, has graciously consented to come in his place. To my left is Judith Harris, primarily an employer lawyer from the firm of Harris & Kahn in Philadelphia. To my right, Judith Vladeck of Vladeck, Waldman, Elias, and Engelhardt, who is an employee's lawyer. And last, but by no means least, Robert Fitzpatrick of Fitzpatrick and Verstegen, Washington, D.C., who I always thought of as a plaintiff's lawyer, but who tells me that now he is a switch hitter and serves on both sides. Bob's views are not, however, neutral. I think he continues to be an employee's lawyer at heart. As we progress through today, I'd like you to consider some unanswerable questions as to why the Supreme Court is moving in the direction it is. Most of us know that the federal courts are overburdened. There is too much work. RICO cases, drug cases, criminal cases are taking priority and making trials of other cases difficult. In fact, Judge Ritchie is not here today because he's in the middle of a very significant drug cases. I think that it might be that the Supreme Court is trying to cut down the extent of employment cases. The question that we have to ask is whether every terminee should have the right to have a full trial. The Supreme Court now seems to be saying, let's cut some of these trials out by making summary judgment easier in cases, following the trilogy of Matsushita, Anderson, and Celotex, which is now being applied in summary judgment cases. Burden of proof requiring the plaintiff to have a very good reason to come into court and take up trial days is being used to weed out cases. Others, on the other hand, argue that this is a conservative court, this is an employer-oriented court, this is a court which does not want to second-guess business judgments. It also seems to want to cut down the multiple causes of action. Someone fired once, I think the court would say, should have one day in court under one set of rules and not 4 or 5 or 10 different causes of action. As we can go through the cases today, I think we ought to consider which way the court is going. And we will do that during the course of the day. We're going to start first with the Hopkins versus Price Waterhouse case. And our format will be that one of the non-neutrals, non-judicial or governmental people, will present the case. There are questions which you will find in your book starting at page 101. which will then be given to the panel. Let me first ask Judith Vladeck to tell us about sexual stereotyping in the Hopkins case.
Thank you, Peter. Just to comment on your opening, I don't think there's any question about which way the court is going. The Hopkins case arose when Ann Hopkins, who was an exceptionally well-qualified candidate for partnership with Price Waterhouse, was passed over. Price Waterhouse, of course, is the nationwide accounting firm which in 1983 had more than 600 partners, 8 of whom were female. Hopkins was herself an outstandingly qualified candidate. She had brought in business worth almost $45 million in the year preceding her candidacy. She had billed more hours than any other candidate. She was highly recommended by her clients, and she was uniformly praised for her integrity and her character. She was the only female candidate in the year that she came up. The all-male partnership committee focused almost exclusively on her personality, and in particular on her unladylike characteristics. Behavior that would have been expected in a male was deemed a liability, and she was told that she needed a course in charm school. Some evaluators criticized her interpersonal skills and described her as abrasive. Some comments were that she was macho, that she overcompensated for being a woman. She was criticized for using profanity because it's a lady using foul language. In some, she was told, and this is a quote, that to improve her chances, she should walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. The trial judge found that it was legitimate to emphasize the interpersonal skills in partnership decisions and gave credence to Price Waterhouse's complaints about her interpersonal skills. However, he said that the defendant had unlawfully discriminated against Hopkins by giving effect to the partner's comments that resulted from sex stereotyping. The Court of Appeals affirmed, holding that even if a plaintiff proved that discrimination played a part, the defendant would not be liable if it proves by clear and convincing evidence that it would have made the same decision in the absence of discrimination. The Supreme Court ruled 6-3 that under the circumstances of this case, which it called a mixed or dual motive case, the employer has the burden of proving that its refusal to promote was based on the non-discriminatory reason. The court said that evidence of sexual stereotyping can establish discrimination. There was no single majority. Justice Brennan, joined by Justices Marshall, Blackmun, and Stevens, would have required the plaintiff to show initially only that discrimination was a motivating factor in the adverse decision. Justices White and O'Connor concurred, but they would have required the plaintiff to show that discrimination was a substantial factor. Justices Kennedy, Scalia, and Chief Justice Rehnquist would have found no liability at all, saying that the district court had made it plain that sex discrimination was not the but-for cause of the denial of partnership, and that therefore Hopkins had not met the requisite standard of proof. On the issue of interpersonal skills, I would simply like to refer to a paragraph in the Brennan opinion, who said that now turning to the memorable advice that was given to Hopkins, that is the charm school type advice, it does not require expertise in psychology to know that if an employee's flawed interpersonal skills can be corrected by a soft-hued suit or a new shade of lipstick, perhaps it is the employee's sex and not her interpersonal skills that has drawn the criticism. While the case was called dual motive, implying both permissible and impermissible motives, in my opinion, it was error to do so. When their proof of consideration of gender is so strong and clear, it is unreasonable, indeed, in my opinion, beyond reason, to believe that her personality and personality-related conduct were not perceived as inappropriate because of her gender. Assumptions based on sex or race or religion of the individual constitute discrimination, intentional discrimination, in its classic form. Just reading the amicus briefs in this case most sharply focus the issue of stereotyping. The women's groups quoted Jean Kirkpatrick reflecting on her time as ambassador to the United Nations. Ambassador Kirkpatrick said, "I've come to see here a double bind. If a woman seems strong, she is called tough. And if she doesn't seem strong, she's found not strong enough to occupy a high-level job in a crunch." She also noted that these evaluations express a certain general surprise and disapproval at the presence of a woman in arenas in which it is necessary to be what for males would be considered normally assertive. And she said, "When I have replied to criticisms of the United States, which is an implicit part of my job, I have frequently been described as confrontational. It was a while before I noticed that none of my male colleagues, who often delivered more confrontational speeches than I, were labeled as confrontational." On the other hand, the brief of the Solicitor General, Charles Fried, said, "In order to make out a case of discriminatory denial, it must be shown that the stereotyping was part of a motive which improperly disadvantaged the applicant." And all along, I thought that the anti-discrimination law was aimed at eliminating stereotypes and requiring appraisals on the basis of merit and qualification.
Well, of course, Judy, Price Waterhouse said that they were, in fact, working from what her work performance was and from an appraisal of her personality. The evidence of sexual stereotyping, I thought, was fairly weak in that particular case. Most of the quotes came from people who were in favor of her becoming a partner, and the decision was very, very difficult to make, because it's very difficult to become a partner in one of the huge accounting firms or law firms. Judy has raised some questions. Maybe Judge Patel would like to take the first one. Does the Price Waterhouse decision effectively give the defendant an extra bite at the apple in attempting to defeat a plaintiff's disparate treatment case, or is it fair? How do you handle that in the context of a trial?
Well, actually, I don't think it gives them a second bite out of the apple. I think what has resulted as a result of Price Waterhouse is that we may have different groups of apples, or maybe even apples and oranges that we're looking at. Because I'm not sure what a mixed motive case is when reviewing Price Waterhouse and then looking at the Burdine type of case. If a plaintiff comes in and says the defendant has used discriminatory, non-legitimate reasons for terminating or not offering me a partnership, and the defendant then comes in and offers legitimate reasons for why the termination or failure to promote occurred, but indeed cannot overcome the evidence that the kind of comments and stereotyping that was involved here which are part of the record occurred, do you have a mixed motive case? When do you decide whether it's a mixed motive case? It seems to me, to some extent, this may be the one case that helped plaintiffs, because the burden is on the defendant to come forward, and not only come forward, but to, in fact, carry the burden of persuasion when there is this, quote, mixed motive. I think it makes it very, very difficult for the court to sort out pre-trial and maybe even during the course of the trial, whether this is a Burdine case or a Hopkins case. And if I were a plaintiff's attorney, I'd try to make it a mixed motive case, I suppose, and the defendant is going to do the opposite. And while the burden is less than the district and the Court of Appeals court put on the defendant in Price Waterhouse, it's only by a preponderance of the evidence rather than clear and convincing. I think this is still the one bite they get. But this time, they have to take a bigger bite because they really have to prove it up rather than just shift the burden of production.
If I could just add one thing, it's no different than the First Amendment retaliation cases. In fact, the Supreme Court quoted the Mount Healthy standard, which has been around for a dozen years. When a public employee exercises First Amendment rights, shortly thereafter, there's an adverse employment decision. Now, why was that decision made? Because of his exercise of First Amendment rights or because of some non-First Amendment reason? And as far as I can tell, judges and juries have been handling that all the way through. And Justice White said that's the same standard that has to be applied here.
Yeah, the juxtaposition of one event followed by the termination is a very tough standard to beat. Any judge can come ahead and say, or a jury can say, well, okay, I think that the juxtaposition is enough. It may or may not have been true, but it's a judgment call. It's that one iota extra that you need for preponderance of the evidence, and it's a factual resolution that you really can't even appeal.
But these cases are never neat packages. You have a lengthy history very often of employment conduct and conduct by the supervisors and the employee that you're going to have to look at. I think you could turn almost any case, if you're a good lawyer and a judge looking at the record may be able to turn almost any case into a mixed motive case. So I think it's going to be very hard to know who's going to have the burden at the outset of these cases.
Yeah, Counsel Shanor, do you think that this part of Hopkins apply only where a plaintiff offers direct evidence of discrimination, or can you use it when you're dealing with some kind of circumstantial evidence?
Well, the fifth vote for the court's decision from Justice O'Connor indicates that direct evidence does need to be used. However, it does appear to me as though the concept of direct evidence is relatively broad. For example, sexual stereotyping comments by some individuals in a multi-individual decision-making body are, to me, not as direct evidence as the evidence that we saw in many lower court cases before Price Waterhouse against Hopkins. I also, like Judge Patel, believe this is basically a pro-plaintiff's case, though in cases that would generally be relatively good, strong, easy-to-win plaintiff's cases, even under McDonnell Douglas. However, what it seems to me has happened is that the employer gets one bite at the apple either way, but that the bite is a lot harder for the employer to swallow in a Hopkins case because the employer has to show that it would have reached the same decision anyway, perhaps by objective evidence, though there's not a clear majority on that point, and certainly by evidence that's more than those who had made discriminatory comments sort of now, after the fact, when their motives are very suspect, coming on board and saying, but I would have done the same thing anyway.
You don't, in the trial, speaking about not neat packages, you don't wait until there is evidence or that there is a decision that sex in this case was in the picture, to use the terms you use. The trial just goes on in a flow. The judge doesn't look down and say, well, here is the time that you have to come up with your evidence of pretext. You don't bifurcate it that way, do you, Judge Patel?
Not ordinarily. I mean, it will come in both through the cross-examination of witnesses called by the plaintiff, will come in on the defendant's case in chief, and then it will come in again on rebuttal. The other thing, with respect to the use of terms of direct evidence and objective evidence, I'm not sure that the members of the Supreme Court even agree on what that is. I certainly don't gather from the opinion that there is a consensus on what direct and objective evidence is, and I'm not sure you get much of a consensus among judges and lawyers about that either. So what does it mean?
Does the plaintiff, Counsel Shanor, have to have a burden, if you will, of identifying precisely the role of the legitimate and the discriminatory motives played? What's their burden, do you think, since you're usually on the plaintiff's side?
Well, I think the answer is no. The plaintiff doesn't have to show precisely what role each legitimate and illegitimate factor involved. What the court says is that the plaintiff's duty is to show that sex was a substantial factor in the decision. There's a lot of play in the joints with the term substantial factor, and I think the court deliberately, certainly Justice O'Connor and the Brennan plurality, chose that term very carefully, knowing that courts and juries in ADEA cases would be required to apply that pragmatically, given the facts of each separate case.
Does anybody on the panel care to tell me what the difference between a motivating factor, a determining factor, a substantial factor, or a but-for factor is?
Sure. But you see, you employment lawyers have been out of the First Amendment too long. Those are all factors that have been plugged into First Amendment retaliation cases for, for 15 years. Mount Healthy is a case that goes way back, into the middle 70s, and says that if an adverse employment decision is made of a governmental employee because of his or her exercise of First Amendment rights, then it's a 1983 violation. And they said a substantial factor, a motivating factor. Doesn't have to be the sole motivating factor. A substantial motivating factor. Now, Justice Brennan says that's what we're talking about. If it's it played a substantial role. Now, in a mixed motive case, you can't say, well, it was 20%, 30%, or 50%. You simply can't compartmentalize someone's motivation. But these standards have been used in the First Amendment area, and Justice White very carefully says, let's just bring over all that law in the First Amendment retaliation area into a sex stereotype area as well.
So we all have a new body of law to read before we try our next case. Let's move on now to the other major burden of proof case in the Supreme Court this year, Ward's Cove. Just briefly, as we all know, under the McDonnell-Douglas Burdine standard of burden of proof, we have this tripartite question of burden of proof. The statute bars discrimination in employment because of race, sex, age, etc. I always viewed that as a question of intent, a question of what was going on in the mind of an individual or in the collective psyche of a business organization. We can't get the business organization on the couch, although the plaintiff's counsel will normally try to do that on cross-examination. Only the defendants know for sure, and when only the defendants know, they generally don't admit it, that we don't have a case if they admit it. So the courts are forced to use what I conceive of as circumstantial evidence of discrimination, and they've developed a complex order of burden of proof. The disparate treatment cases, those that are really intentional discrimination, the rubric is, I think, that the plaintiff has the burden of producing a prima facie case. They do that very simply. They show that they're a member of one of the protected classes. They show that there's been an adverse employment decision or action against them. That's easy. And they show that somebody who is not in the protected class was treated better. Then, miraculously, the burden shifts to the defendant. It is a burden of production. It is not a burden of persuasion. And the defendant who knows why that the act was done must articulate a non-discriminatory business reason for the action. If they fail to articulate that reason, I guess the presumption is that business people are reasonable people, and if they're doing something for no reason, they must be hiding the bad reason, a consciousness of guilt kind of thing. They lose. However, if they do articulate a business reason, then the plaintiff has the ability to show that it is a pretext. This is a burden of persuasion. You show it by statistics. If the numbers don't add up, that's a pretty good way. You show it in admissions, any writing that was ever made out in California with the I guess the Federated case, somebody wrote down the age of the people he was firing, and that piece of paper was used as an admission. Smoking gun statements said in camera that come out. Inconsistent statements, and again, consciousness of guilt, untrue justifications. I fired Joe because of this, and there is proof that the reason alleged simply didn't exist. And then the courts got to a more difficult area in Griggs, which you'll find talked about at page 6 of the materials. Somebody said, I'm going to select people I hire on the basis of a criteria which is neutral on its face. In that case, a high school diploma. That was a test, a surrogate for reading, writing, accomplishment, performance. The statistics, however, showed that if you used that as a criterion for the job, it would have an adverse impact on minorities, because minorities had apparently less high school diplomas than the non-minorities that were applying. So the court says that if the plaintiff will show the adverse statistics, then, at least we all thought, I think we all thought, that the burden of persuasion shifted to the employer, and the employer had to show a valid business necessity for the selection criteria. If the employer failed to show that business necessity, then you were going to lose the case because you had the burden. Last term, in the Watson case, which you'll find referred to on page 7 of the materials, the court, for the first time in a rather split decision, did say that you can use this disparate impact model where you have a feeder pool of people coming up to supervisory positions, coming up for promotion, and the promotion numbers showed a disparate impact on minorities. And I think most of us thought that that meant that the employer was then going to have the burden of persuasion that there was a business reason behind each one of the promotions. This year, however, in Ward's Cove, a very complicated case in my view with a lot of factors, but in Ward's Cove, which is at page 7, we had several things happen. First of all, the court said, rather gratuitously I thought, that the burden of persuasion in the Griggs disparate impact kind of cases is always on the plaintiff. The plaintiff has to prove lack of business necessity. Proving business necessity or non-business necessity, having the judges second guess that decision, is a very difficult burden. But what happens in Ward's Cove? In Ward's Cove, we had a seasonal salmon cannery in Alaska. It was only open for a few months. When they went to hire people for the line, they hired them locally. The majority of the people there were Native American Aleuts and Filipinos. When they went to hire the more skilled people, the truck drivers, the accountants, the doctors, the boat captains, and the clerical workers, they went down to Seattle and hired, or they went to a mostly white union. They also gave a rehire preference to people who had worked there before, and they also gave a preference supposedly on nepotism. When you looked at the statistics, you could come up and say that there was a higher percentage, a much higher percentage, of the minorities in the lower paid cannery line cases, and a very, very small, almost minuscule number in the higher paid jobs. And the courts below had said, well, that kind of proves discrimination. The Supreme Court said a couple of things. One, if you're going to do statistics, you better compare apples to apples, and apples to oranges is not a valid reason. If you want to show a statistical disparity, you must show the numbers of available qualified people in the minority groups for the jobs that the whites got, and this the courts below had not done. The court said that to make a prima facie case, you have to specifically identify the suspect neutral criteria. In Ward's Cove, it was nepotism, rehire preference, and those two came because their last year's group was predominantly white and the higher priced, and separate hiring channels. then you have to show that they're causally linked to the statistical disparity. Then the defendant has a burden of articulation, of a justification for the practice, a rationale for not using the alternative means with less impact, but they need not prove, the defendant doesn't have the burden of proof to show that the practice was either essential or indispensable. And the sense of that decision, we believe, I believe, is that the court is telling the lower courts, it's not your place to second guess business decisions. It is your place to handle the very, very bad cases, but not the close cases. If it's a close case, the business decision shouldn't be second guessed. Now, this is a tough burden on the plaintiff. And if you look at page 11, the Johnson Controls case, which is one of the cases that was decided by the Seventh Circuit en banc in following Ward's Cove, it went off completely on the burden of proof case. Burden of proof question. Johnson Controls had said that in making lead-acid batteries, we do not want fertile women working because the lead might cause damage to unborn children. And the court said because the UAW showed no other plan to protect the unborn, it accepted that the unborn as a valid business reason, that the case should go on summary judgment and dismiss the case. So the burden of proof is, I think, going to be used more and more to get some of the wilder cases out of the courts. Judge Patel, I have a statement here in my questions. Is it true that whoever has the burden of proof of business necessity is going to lose? Is that your experience?
I think that if the plaintiff has the burden of proof on business necessity, that the likelihood of winning these days is going to be very, very difficult. I think it's much easier for a defendant to prevail, because I think that you're correct. The Supreme Court has said several things in this case, either implicitly or explicitly. One of them is that they don't like courts second-guessing business decisions made by employers. The use of the term legitimate business reason as being one that will justify an employer's action suggests a fairly wide latitude. The requirement that in order to overcome this, a plaintiff would have to show equally effective means suggests almost an impossible burden for plaintiffs. I think it's a very, very difficult burden for plaintiffs. I think it is an easier burden if it's on the defendants, and certainly it doesn't take much for them to come forward with evidence and then shift the burden of production, and of course the burden of persuasion, according to Ward's Cove, now relies solely on the plaintiff.
Yeah, but that's the second part of the case. The first part of the case, where it's the plaintiff's burden even to get to first base. We're talking about third base over there. But first base, he has to isolate and identify particular employment practices that cause the adverse result. And, I mean, isn't that a much harder, I mean, you can't even get to first base.
I agree with you, yes. I think the other things this court is saying is they don't like statistics in employment cases. I think they've made that clear in other cases. Justice Kennedy certainly made that clear when he sat on the Ninth Circuit as a Court of Appeals judge. The kind of statistical pools, I think that the court was accurate with respect to the kind of statistical pools that it talked about. But the ability to take, for example, objective employment standards that are discriminatory and trace each of those is almost an impossible task. Heretofore, what a plaintiff's lawyer could do is put in a number of proscribed practices and show an adverse, essentially show the statistics, and then it was the defendant's burden to prove that in fact there was some legitimate business reason for all of this. That's not the case. There's going to have to be a lot of tracing, and I think in many of these it's going to be almost impossible to do. So I agree with you. They may not get past first base or even get to first base.
As a practical matter, I think there are few plaintiffs' lawyers left who could afford to litigate a Ward's Cove case, and I think one of the messages of this case is it begins to put the burden now on the government, even more so, to enforce the act.
Well, why is it so difficult for the plaintiff's lawyers to say in deposition, what were the factors? What were the reasons? And therefore pin down the operating people in a very short way as to what the reasons are.
It's a totally unrealistic question, Peter.
Partially unrealistic?
It was difficult enough when we had the inexorable zero, or virtually the inexorable zero. There were no blacks, there were no women in the upper level positions in order to get anything out of the employer's records. Don't think it's as easy as you suggest to get district court judges or the magistrates to permit you the kind of examination of the employer's practices that you're suggesting. Just ask them. They'll tell you what they do that has resulted in all of those problems. Unless you're going to have the possibility of a presumption arising from that overwhelming statistical imbalance, you're not going to be able to get the information that you're speaking of. The judge is going to say, you know, you don't come into this court unless you're prepared to prove your case. You're not going to make it through discovery. You have run into that. You're a defendant's lawyer.
My discovery for defendant's lawyer seems rather broad. Counsel Shanor, how do you go about finding out the discriminatory methodology? How do you go about finding out and proving the alternative methodology when you go into these cases?
Well,
You've got the deep pocket.
I guess I'd like to back up a little bit and respond a little to Bob's comments earlier. I do think that one effect of Ward's Cove, and probably of Patterson also, will be to shift more employment discrimination enforcement activity to EEOC from the private sector. These are cases that require a lot of work. Indeed, this was not a very healthy area of plaintiff's practice well before Ward's Cove came down. The number of class actions that private plaintiffs' lawyers brought declined from 1977, over 1,100 cases, to 1988, under 50 cases, well before this decision was handed down. Also, I think that there was an expansion of the disparate impact theory, just the term prior to Ward's Cove, in the sense that practices that were subjective in nature were brought under the disparate impact umbrella. I do think that the shifting of burdens of proof, particularly if the courts interpret the shifting and the application in the way that the Johnson Controls case did, are going to make it much more difficult for plaintiffs. On the other hand, I personally believe Johnson Controls is an aberration. I think it was wrong in the way it applied Ward's Cove. I think it was wrong in the way it took all of the factors of a business necessity defense in a disparate impact area and transported it into a disparate treatment area. And I think that it's unlikely, as Allen against Seidman, I think, indicates, that Johnson Controls is going to be the norm for how Ward's Cove is applied. I do agree that we're going to have to do at EEOC very thorough investigations of the employer's reasons and look at alternatives carefully. I don't believe we're going to have to explore every aspect of every potential alternative and its technical feasibility. I think, for example, if you find that 3 different tests are used to select for particular jobs around the country, and that one has a much lesser impact than the other 2, and that that's well known in the industry, that the plaintiff's burden in those kinds of cases will not be so hard. I also think that there's a lot of play in the joints on the issue of how precisely do you have to pinpoint the disparately impacting practice. And I personally am prepared at EEOC to argue that where the employer lumps a whole bunch of factors together in its decision-making process, that those things should be used as a unit as the employer used them as a unit. Though in a case where they're separable, we have for some time now been trying to separate them out, since Connecticut versus Steele, for example, to point at the test or the diploma requirement or the, whatever it was.
Well, Judith Vladeck talks a lot about the burden on the plaintiffs of finding things out. There are some very cheap discovery methods that can be used. For example, you file a charge with the EEOC or the state Human Rights Division, and you let them go for a little bit, and the employer puts in a statement of position to try and get the EEOC off its back. That statement of position now fixes the reasons. They can't really go beyond those reasons, which means that when you do that, what seems to be a kind of simple thing, you've got to, as an employer's lawyer, you have to go all the way to the Supreme Court with it in your own mind to be sure that you're absolutely right, that it's absolutely defensible, because anything you don't put in there will be considered a pretext later on, and anything you say that turns out to be wrong will show up as consciousness of guilt, so that there is a lot of information. And proving alternative methods, it seems to me, is very little more than finding an expert who will testify that there was an alternative method, and come in and be what Judge Ritchie always calls not an expert witness, but a witness who can express an opinion in court.
Yeah, but you're still looking at the second part of it. I mean, you know, the first part, isolating and identifying the factors. If I could put one question to our EEOC counsel, Justice White made quite a to-do about the employer having to maintain records as to the impact of each of his policies, and he quotes the EEOC regulation on that. What if they don't maintain such records? What's the Commission's position if they don't maintain the required records?
Well, the Commission is prepared in appropriate cases to use that as an adverse inference against an employer and to argue for that position in court. That is, the employer required to keep records that doesn't ought to have the absence of that records taken adversely to the employer's interest. Now, I understand the problems with that and that it won't work in all circumstances.
And Justice White's decision seems to be predicated on the illusion that employers keep these records. So if
well, I think even
EEOC
more
gets this adverse inference, it's going to apply in most cases.
The larger employers all have affirmative action obligations under Executive Order 11246 because they're government contractors, and that's policed pretty well, and they do that discipline. I'm afraid the time has come that we have to move from sex to drugs, and Judy Harris will bring us the drug testing cases.
Well, there were, as you all know, 3 cases that the Supreme Court decided last term that have been designated as the drug cases. They are Skinner versus the RLA, National Treasury Workers versus Von Raab, and Consolidated Rail versus RLA. The 2 I think that have the most significant application are the Skinner case and the Von Raab case, particularly Von Raab. I'll tell you briefly about each of them. Skinner is a case and in which the court, Skinner and Von Raab were decided on the same day. Skinner is a case which involves testing of operating employees of railroads pursuant to Federal Railroad Administration regulations. Although some of the regulations were mandatory in nature, some were permissive. Primarily the testing involved occurred either post-accident and the nature of the test depended on the magnitude of the accident, the extent of the damage, whether employees were involved, the question of fault, and the size, whether or not anyone was killed. The other kind of testing that was involved was reasonable suspicion testing, where supervisors believed there was a reason to suspect that an employee had consumed drugs or alcohol. The Skinner case is predicated on a long line of a record of alcohol consumption in the railroad industry. And I think it's fair to say that the court extrapolated from that use of alcohol and use of drugs. There was some evidence of drug use in the industry, but it did not reach the magnitude of the alcohol use and the documentation thereof. The court first addressed the question of whether the behavior of the railroads was in any way constrained or affected by the Fourth Amendment, and determined that it was because the actions were taken pursuant to regulations promulgated by government agencies. In examining the search, the court looked at whether or not the search was reasonable, whether it was conducted in an appropriate fashion. Determined that there was no need to have a search warrant, and went into a long discussion of how warranted searches with warrants are those involved primarily in criminal process, and secondly, in situations where there was a great deal of discretion in getting the information you were searching for and whether to search. That in Skinner, it was clear when the search would occur. There were rules, employees knew what those rules were, they knew when certain events occurred that a search would happen. Therefore, there was no need for a warrant. Went on to examine the question of whether there was a need for probable cause, which is what a warrant is issued pursuant to, even though a warrant might not be required. And took the position, Justice Kennedy wrote the majority opinion, that where the government or an employer acting pursuant to government regulation was engaged in something other than law enforcement, there might be special circumstances which would permit a search absent a warrant and without probable cause, and that such circumstances existed here given the record in the railroad industry. The testing was the collection of blood and urine, and it involved a breathalyzer as well. The other case, the Treasury Workers versus Von Raab, is a case involving government employees directly. The employees of the Treasury Department brought suit against the commissioner of the
Thanks.
Customs Service, right?
Customs, yeah.
I want to say the drug service. To think about what they were doing. The testing was to be conducted when an employee applied for jobs of a certain category. One category of jobs were jobs involved directly with drug interdiction. The second involved the use of a weapon. And the third involved classified information. The Supreme Court upheld the testing and the search in connection with the first two and not in connection with the third. There was a remand to the Court of Appeals for consideration of the scope of classified employees. I think the significance of Von Raab is far-reaching in that there really was very little, if any, evidence of drug usage in the Customs Service. Indeed, the Commissioner of Customs said, we do a good job. We don't have drug usage. We haven't had problems. There had been some instances of officers killed with weapons or injured, and there had been some officers dismissed for bribery, but there was no connection in those actions to drugs. And absent that, the court found that because of the service's frontline posture with respect to drug interdiction, there was a need, given the societal prevalence of drugs, to permit this testing. The question, I think, that Von Raab particularly raises is, as a matter of logic, can you not extend, certainly in the governmental sphere and in the government-regulated sphere of private employers, the logic of that decision to those involved who could be characterized as involved in drug interdiction, those who are involved in the use of a gun, and from that could you not extrapolate any other dangerous instrumentality? Obviously transit workers, railroad workers, any heavy machinery. How many industries might there be involved in this kind of practice?
Well, I guess one of the questions maybe we ought to ask, maybe I'll ask you or Bob or Judith Vladeck, is where you have a strictly private employer, one who is not required to test for drugs by any government regulation. How does the Fourth Amendment impact? Does it impact at all? What are the federal standards for saying I want a drug-free workforce? Not necessarily a drug-free workplace, but a drug-free workforce. Don't I have the right as an employee to have that?
I think unless you're in a situation where you are regulated by government regulation, the answer to that is yes, you do have that right. Your limitation, or you do have the ability to do that. You might be limited and you might be challenged by state law You might be challenged by a union or an employee in connection with a collective bargaining agreement. You might be restrained under state law by constitutional provision in state constitution regarding privacy. And you might have common law claims brought against you alleging such things as intentional infliction of emotional distress, invasion of privacy, all those sorts of claims under state law. I don't see emanating from these decisions a spate of cases that are going to come along challenging drug testing under the Fourth Amendment. I just don't think it's possible.
Well, if I could just qualify, a lot of states recognize unlawful discharge. Now, I mean, for example, if you exercise your First Amendment right and you're discharged because you exercise the First Amendment right, the private common law tort of unlawful discharge might come into play. California has a much broader right to privacy protection in its constitution. Now, if the employer requirement for drug testing is totally unrelated to anything that they do on the job, I suppose the argument would be that it's really an invasion of right to privacy or unlawful discharge because I'm asserting my Fourth Amendment right and you're punishing me as a result of that.
I would disagree with you that any state, except perhaps Montana, has a wrongful termination tort or an unlawful termination tort. Every one of them are tied to some kind of public policy that is being violated in the termination. If, for example, I decided to pick every third name and fire somebody, there's nothing wrong with that. There's nothing illegal, perhaps even in Montana. But it always has to be tied, doesn't it, to some unlawful background like First Amendment or crimes or some kind of statutory or violation of public policy. You go back to the Peterman case in California, which started all this, somebody who said, I was fired because I told my Teamster bosses that I would testify honestly before the legislative committee. That's where it all began. You have to have a tie to something that's illegal or some protected right before you get to the unlawful discharge.
I think of some of these cases where public employees live together, without being married, and then the public school fires them, or they smoke marijuana on a weekend or something like that, and they test positive for that. And there are decisions that say the constitutional right to privacy would come in to protect them if it's not job related, if it doesn't, adversely affect their job. I mean, the real problem is that every employer is going to say, how could, a drug-free work environment not be job related? I think there's the problem, but I think there are tools there available, even in the private sector, in situations where there's practically no showing, and I'm willing to concede it's difficult to show that, between the use of drugs and something you do on the job.
Well, I mean, for example, I know a lot of financial institutions are saying, I want a drug-free workforce because I have access to money, I can do things, and I don't want somebody who is beholden to the drug dealers. Do you think that's legitimate?
Well, no. I agree that in this day and age, the notion that an employer doesn't have a job-related interest in making sure that his employees are drug-free, I think the courts are going to lean over backwards in that. All I'm saying is there are some situations where the drug use is so minimal and it's totally unrelated to the job and has no effect on the job, where these other doctrines might come into play.
Courts are going to be in a position of balancing some very difficult public policy issues, and that is the policies of right to privacy of employees and the concern about drugs, and balancing those off. And I think you're going to have to look at the particular individual employee's situation, the nature of the employment, and what is known about that employee at the time that whatever kind of testing occurs, whether it's pre-employment or during the employment.
May I add, you really have to look at the state law and determine whether there is any public policy. In New York, nothing will be a sufficient violation of public policy to justify inhibiting an employer's right to fire at will. So that I don't want any members of the audience who come from New York to think that there are any restraints on an employer's right to be totally whimsical
that there might be a claim for intentional infliction of emotional distress.
Only
Texas,
in a very, very remarkable instance. There are very few opportunities for that
it's a
in New York.
tough claim to prove.
Only where we have found, or we've been able to prove once, a very careless use of an inaccurate report of drug use from a urine test that was carelessly tested, and a refusal to do a double.
On the other hand, in New York, Judith, as you know, the New York State Division of Human Rights, which is our local EEOC, and at least one judge in a case called Doe v. Roe, has said that if you're about to hire somebody, you've made him the offer contingent on passing a drug test. He takes the drug test, opiates are found. He gives the traditional poppy seed bagel defense. Actually, he did a variation of it. He said he ate health food bread with seeds, and that shows up as opiates. And the court said, and the State Division is saying, we're looking for a case to take in which we can show that it's not work-related, and the defendant, the employer, is going to have to prove that it is absolutely a bona fide occupational qualification. And if you follow Panken's rule that whoever has the burden of proof on business necessity loses, the employer is going to have a tough time. Now, that case is going up. It's just Judge Edwards.
The employee has to prove addiction there, don't they? It can't be just recreational use. There has to be an addiction for there to be disability. And that's the same analysis that applied in the alcoholism cases. If you're just an occasional social drinker that has a problem at work occasionally because you drink, but you're not an alcoholic.
Either that or New York law has a unique class of person that it protects under its discrimination laws.
No,
people who use drugs.
Actually, they get around it very simply. Under the federal law and under New York law, you are disabled if you are disabled, if you are an abuser, an addict, an alcoholic. You are disabled if you were an abuser and are now cured. And if you've never been an abuser and never been an alcoholic, you're disabled if people think you are. So by talking about the bona fide occupational qualification test, you have virtually proved that we think they are, they're therefore in the protected class, and they get around Bob's problems altogether.
Well, you're better off going into the employer at the very beginning and saying, you know, I'm a recovered drug addict. However, once in a while I have a relapse, because you know addicts really have a hard time fighting it.
Let me give you an analogy. You know, these lie detector tests were around for a long time, and they were favorite devices for, for checking up on things. And there were so many abuses, and they went into so many, they got extended to so many different areas that finally, various states and now the federal government has come in and say, hey, you can't use a lie detector test every time you think you have a problem, because they don't work that well and they really are an invasion of privacy. I think some of the states are going to come along and regulate drug testing.
They already have.
And say yes and say no. In other words, and that may be in saying yes, you can do it under some circumstances, and saying no, you can't do it under others, that may be the best protection an employee who wants to protect their privacy are going to have in the future. I agree, the common law, torts are not under the existing state of the law an adequate device for protecting against it.
Well, Judge, how do you feel how would you come out if there was mandatory drug testing for judges under the Van Robb decision?
Probably the same way I've come out when it's involved truck drivers and others. That random testing, I think, is still not permitted, and I think you have to make some more showing than just what is necessary to obtain random testing. I don't know, we have to find out, I guess, whether or not it impacts on the judge's ability to write an opinion more coherently, or not.
It certainly affects the safety of litigants.
Well, fortunately, we have a couple of layers, so we can't do too much damage at the district court level.
Judith, you want to raise some of the questions you raised for the panel?
Well, I think the major one was the one about how far can you extend it to employees who perform jobs that may endanger others. And I think that what falls under that is very, very broad. And it seems to me that if you devise a program that tests employees that you can arguably say are involved in work dangerous to others, that that takes into account their sensitivities and their rights to privacy, if you will, that you could probably justify it.
Now, there's no question that drugs are probably one of the biggest issues overlaying all employment these days. We have the Drug-Free Workplace Act, which is really a paper tiger. It really doesn't do very much, as far as I can see, to end drugs. But there is an effectiveness that you have to watch out for all your clients of the special safety regulations in mass transit, the Urban Mass Transit Authority regulations, the Department of Transportation regulations, the FAA regulations are beginning to require mandatory testing of people who work in what are called safety-sensitive areas. I think this is probably going to be one of the most fertile fields for litigation that we're going to see in the 90s. Let's turn now to Professor Friedman to tell us about Lawrence versus AT&T.
Well, Lawrence was another of the problems that the Supreme Court has focused on as to the triggering event in a claim of employment discrimination. And the way the Supreme Court treated the Lawrence case, it was a continuation of two earlier decisions, Delaware State College against Ricks and United Airlines against Evans. And the problem in all three of those cases is that when does the discrimination occur when a policy is adopted or a decision is made or when its impact is actually felt? Now, in Delaware, in the Ricks case, a teacher had been told that he would not be given tenure, and in accordance with the normal academic procedure, he had a whole year before he actually stopped working there. And in that year, by the way, he had all kinds of administrative appeals that could have been taken up through the faculty. He had various administrative hearings that he could have taken advantage of, none of which, of course, would toll the statute of limitations. And what he did was he finally filed his EEOC complaint within 180 days after leaving, but not within 180 days after being told that he would not be rehired. And the Supreme Court said, well, it's now too late. You've got to, the minute you know that this adverse decision is going to happen, even though the actual event is off in the future, you've got to take action at that point. Now, if you were trying to keep cases out of the federal courts, it's a very bad decision because you're getting people to jump into federal court a lot earlier than they ordinarily would have, because it may be that the decision gets reversed or something else happens in the meantime. But that was a case which, even though it was adverse to that particular plaintiff, encouraged people to jump into court at the earliest possible moment. Now, Lawrence is a similar type of case. There was a change in the seniority system at this plant. And before 1979, seniority was determined on the basis of total years spent in the plant. In 1979, the system was changed in a collective bargaining agreement so that the seniority of testers, which were a more advanced position, was determined according to the number of years as a tester rather than years as seniority in the plant. Now, the effect of the change, at least potentially, was to adversely affect certain women workers who, although they had plant seniority, did not have tester seniority. Now, again, if they were testers for 5 years, they would regain their plant seniority. So it might never affect them. If they just lasted that 5-year period, then their seniority would go back to the other system. If there was no layoffs in that 5-year period, then in fact they would not suffer any injury because they would go back to the place in line they had before that happened. Sure enough, in the Lawrence case, a woman who did not last those 5 years. She had planned seniority, but she didn't have tester seniority, and she didn't work for the 5 years that would allow her to regain her tester seniority. Now, after she was laid off because she didn't have the appropriate seniority, she brought an EEOC complaint outside the 180-day or 300-day period, and the question was, did the statute of limitations run? Now, it was a 5-4 decision. Well, actually, it was a 6-1, I guess 5-1-3 decision. Justices Blackmun, Brennan, and Marshall found that there was no bar, statute of limitations had not run, but they never believed in the Ricks or the Evans decision to begin with, and they were simply reasserting their opposition to that way of calculating time. Justice Stevens concurred, saying, I think Ricks and Evans really require the result that we reach here, and since we're not prepared to overrule it, I will concur with the 5-person majority that found in her favor. But the real problem is, when do you suffer concrete injury? The majority said you suffered concrete injury when the policy, the new policy, went into effect, even though it might never hurt you. If they just lasted out that 5 years, or there was no layoffs in that 5-year period, it never would have affected them. But what the Supreme Court said was, well, I'm sorry, you suffered concrete, or at least the potential for, you suffered concrete injury, and you would really suffer injury if something happened in that 5-year period, but you really suffered injury when that new seniority system went into effect. Now, there's been a subsequent district court decision that's at page 47 in the materials, a case out of the Northern District of Illinois that adds somewhat of a gloss on that, Artists Against United States Industry, that requires the plaintiff to show, well, it's a 3-part test. The original action which the plaintiff complains about must be outside the limitations period, but the court went on to say the defendant must demonstrate that the plaintiff knew or should have known that he or she would have suffered or would suffer concrete harm. And third, the defendant must demonstrate that the plaintiff knew or should have known at the time of the original action that it was discriminatory. So the district courts, I think, have are reluctant to apply Lawrence and all its very harsh implications. And they would require that the policy be obviously discriminatory so that a neutral policy, for example, would not qualify under the Lawrence rule. And they would also, at least this decision would require that the defendant must show, putting the burden on the defendant, to show that at the time of the original action that he would know that he could suffer concrete harm. I guess as a procedure professor, I look at this case and try and imagine what would have happened if these plaintiffs had brought suit right after the policy had been put in. Judge Patel, I mean, wouldn't they have a standing problem?
I think probably most district court judges would have dismissed the claim at that point and said it's not ripe, you don't have standing, you haven't been injured, it's purely conjectural. In fact, I think that Lawrence is hard to understand in the context of most standing injury cases in the whole spectrum of federal case law. It's made even more difficult by some language in the holding, which says, in holding that when a seniority system is non-discriminatory in form and application, it is the allegedly discriminatory adoption which triggers the limitation. In other words, you have something that is facially neutral, presumably, and it does not appear to be discriminatory on its face. And therefore, you have people who have to divine whether sometime in the future there may be some adverse implication. So it's not even a case where this was not even a case where it was apparent on the face of it necessarily that there might be adverse impact at some point in the future.
Well, because the policy was a tester versus planned seniority. I mean, on the face of it, it doesn't say anything about one sex versus the other. Yet.
Well, I have to say, on the other hand, there is built into the statutory language of Title VII and the ADEA a reverence for bona fide seniority systems. That is something that is untouchable, and the courts have held it virtually untouchable.
So protect them by making it impossible to sue. Either you wait too long, or you are premature, and now they are insulated not only by the statute, but by the Supreme Court's procedural thicket.
I think it raises some interesting questions. For example, what if when the collective bargaining agreement is renegotiated and those same provisions are contained in it? Does the statute start to run anew? What about a new employee who comes in and who was not on the scene at the time that the collective bargaining agreement was negotiated? Does that person have to bring an action immediately upon being hired? Or it raises all kinds of
And can they bring class action on behalf of everybody? I mean, that's
And can they sue the union for failure to represent? Because you get into the next level if the union actually does.
Oh, that the Supreme Court would permit. I'm sure they would find a way.
I mean, as a practical matter, who has a client who works for someone who files charges and lawsuits against their employer? 99% of the time it happens after you're terminated.
If they are smart, the best thing you can do for job security is to file that charge. Because now you may be a white male under 40 who's not protected, but you're a member of a protected class, retaliation. And my experience is that the EEOC protects against retaliation very, very strongly. Probably one of the most strong things that you do is to protect against retaliation.
Oh,
I
but if
don't
there's
have
a
very
consent,
many clients who want to spend the rest of their working days looking over their shoulders, worrying about things like that.
Well, you see, we started off talking about effect on the lawsuits in the federal court. Here is a case that said go rushing into federal court as soon as you can, whether or not you know it's really going to hurt you or not, because if you don't, it's going to have an adverse effect down the line. I wonder how the EEOC feels about all this.
The EEOC's views are very clear. I argued Lawrence on behalf of Patricia Lawrence and lost, and still believe that the decision was wrong. I don't know that I can agree, however, that this is going to lead to lots of premature suits. Presumably, if a policy is challenged up front early on in one lawsuit, that will take care of the particular seniority system. I do, however, strongly believe, as Bob articulated, that people do not and should not be asked to challenge relatively speculative policies that may or may not affect them in the future, that is simply a bad way of doing business. The Lawrence case, of course, is quite compelling in that regard. These women went 4 years on a 5-year period before something bad happened to them. People don't come to EEOC unless they've been discharged. Over 30% of our filings are discharge filings, even though the number of discharges is minuscule compared with the numbers of hirings, terms and conditions, and other things that happen in the workplace. I think that Lawrence is a good candidate for some legislative work.
Do you read
and
it
I
as
think it's also a case that is likely, as in the lower court case, to be narrowly construed. We're going to be arguing estoppel, waiver, other equitable arguments in cases where seniority systems are challenged as having been intended to discriminate in their adoption.
Is it going to go beyond seniority systems?
Well, Lawrence already went beyond seniority systems, at least to a slight extent, in the Betts case with respect to a bona fide employee benefit plan under the ADEA, but I do believe that it is essentially limited to seniority systems and the like, and I think a benefit plan which is combined with the seniority system provision in 4F2 may be the extent of that limit.
Well, I think of its application in Martin against Wilkes, I guess, which we're about to talk about, a consent decree in a Title VII case going back way back some years ago, and the adversely affected white male working force didn't attack the decree or didn't do anything within a short period of time. Why doesn't, why isn't it goose for the gander, or whatever that expression is? Sauce for the goose as well as the gander.
Hopefully that's a signal that Lawrence is limited to disparate treatment, seniority type change type cases, and maybe it is limited to a 703H seniority system type challenge. And maybe it is that narrow a decision. Otherwise, it's hard to harmonize it with Wilkes.
Well, the Supreme Court does at least attempt to harmonize the two by saying that the seniority system in Lawrence was not facially discriminatory. The consent decree in Martin against Wilkes, on its face, provided racial preferences.
And therefore what? I mean,
the question is, I think it's a fair question. Should the court be making that distinction? But that is the distinction that I think the court has made.
The logical consequence of that would be, therefore, you are already on notice of the adverse consequences of the consent decree, and it behooves you to get into court right away and either intervene or take some action to protect your interest and not be encouraged to sit back. They reach what I think are inconsistent conclusions by making this dichotomy.
Where you're less likely to know that your rights have been violated, the statute has begun to run. Where it hits you right between the eyes, the statute has not begun to run.
Well, and I think that Lawrence is the one of the two on that ground that is wrong. In either instance, the employee should not be encouraged to make a premature challenge. The white employee who's operating in a workplace where there is a racial preference under a consent decree shouldn't be encouraged to walk into federal court and challenge that on its face when he or she may never be affected by it personally.
I think this is maybe a good time to segue into Martin v. Wilkes. Bob, you're going to present that case.
Sure. Martin is an interesting case. It involves the impermissible collateral attack rule. Prior to Martin versus Wilkes, consent decrees had not been susceptible to collateral attack by parties who had not been either parties below or privies to the parties below. The courts had discouraged later attacks on consent decrees that contained, for example, affirmative action provisions. Martin versus Wilkes affected a dramatic change in that body of law. In a 5-4 decision, the majority opinion written by Chief Justice Rehnquist, the dissent written by Justice Stevens, the court held in a case involving an attack upon a consent decree in a decade-long piece of litigation coming out of Birmingham, Alabama, involving the Birmingham Fire Department. The court permitted white dissidents who had been on notice at the time the decree was entered of the decree and of the provisions of the decree, allowed them subsequent to those proceedings, having failed to intervene below, allowed them to collaterally attack in a new civil action. And the court, the majority, focused on a Federal Rules of Civil Procedure analysis of the case and looked at Rules 19 and 24. Rule 19 dealing with joinder, 24 dealing with intervention. And the court said that joinder as a party, not knowledge of a consent decree and an opportunity to intervene under Rule 24, is the method whereby persons become subject to the court's jurisdiction and become bound by a judgment or a decree. The dissenters, led by Justice Stevens, emphasized that the opportunity was there for these dissidents at the time the decree was entered to attempt to timely intervene and challenge it in that fashion under Rule 24, and having failed to do so, they should not now be allowed to come forward and attack it. Justice Stevens talked about the dissenters' fear that this opinion would now lead to endless litigation over affirmative action consent decrees, and that it would discourage settlement in these cases. The Chief Justice, speaking for the majority, emphasized that the burden was on the parties who were negotiating the consent decree to determine who were the individuals in the community who would be affected by this decree, and to take commonsensical efforts to join these people and bring them into the proceedings so that they could not later collaterally attack the decree.
Just let me get your comments, Counsel Shanor, first on that particular case. I guess the thing is that if you analyze the sense with a sense of notice, as in Rick's, the individual knew that the act was done.
No question.
That these people knew exactly what was going on. What's the statute of limitations that they're going to be faced with?
I think the Supreme Court says the statute of limitations is 180 or 300 days, depending upon the state, from the time at which an action is taken pursuant to a facially discriminatory or facially preferentially treating consent decree.
Why doesn't that say that you have to file your attack 180 days after the consent decree is entered, assuming that you know?
I think because the court, whether it's right or wrong on this point, we've already talked about, but the court seems to be distinguishing between facially discriminatory systems which it believes can be attacked at any point when they are applied, in the same way that a disparately impacting test can be challenged within 180 days after the impact, not the giving of the test or the adoption of the test. That seems to be the way that the court is looking at it.
And so you're really focusing on that seniority aspect, the preferred status of seniority systems.
I believe without the preferred status of seniority systems that Lawrence would have been decided differently.
You know, I have another problem with that case because they remanded on whether they would have a defense on the merits. In other words, that was a pure procedural determination.
Which case, Leon?
I'm talking about Martin against Wilkes, that it's not res judicata. Now you go back, and what the judge in Alabama had said, there are two reasons why I'm throwing this case out. One, you know, you're barred by res judicata. Number two, the city has a defense on the merits. It is a business necessity to obey a consent decree by a federal judge. And the Supreme Court didn't say anything about it. What they said was we remand to the 11th Circuit for a determination of that, you know, of that part of it. Why won't the 11th Circuit say, well, thank you very much, it's not res judicata, it's not a procedural decision, it's a substantive decision. You have a business necessity defense in hiring people according to the requirements of this consent decree. Thank you very much, case over.
And will that be a defense to a back pay claim, that you are complying with the provisions of a consent decree?
Well, why isn't it...
Assuming that you get past the liability hurdle,
right,
which, granted, is still appears to be up in the air.
But why isn't... I don't understand why that isn't a business necessity to say, yes, I hired 2 blacks over 2 whites because the consent decree required me to do it.
And I am extrapolating, but I believe the court is saying that because these dissidents were not before the court below, they are not bound procedurally or substantively.
Procedurally, you don't have to be bound. I mean, in other words, if an employer makes a decision, he doesn't have to have a hearing, giving everyone a chance to, you know, to come in and give their point of view before he makes that decision. The government employer made a decision to enter into this consent decree. He has to call everybody in before he makes that decision. And if a federal court judge signs that decree, why isn't that, you know, the same as any other employment decision?
Because that person who is later affected by it, and who comes forward in 180 or 300 days, was not before the court, was not joined below, therefore did not have the opportunity as a party below to challenge its legality. And the fact that the district judge approved the consent decree doesn't necessarily make the later effect on that person legal.
Yeah, but you see, you're still confusing procedure and substance, I think. I mean, that's how I would look at it. It's still a legitimate, I mean, if we're leaning over backwards, as we are, to give employers the chance to impose their own, don't look over our shoulder every time we make an employment decision. They made an employment decision, which was ratified by the court, that this sort of consent decree is necessary. I don't read anything in the decision that says that you have to give the adversely affected white male workers, they must come into court. You have to affirmatively drag them into court before this decision is going to bind them. On the contrary, they were very careful to say that they didn't have to come into court earlier, at an earlier time, and there was no adverse procedural reason if they didn't do so.
Well, of what consequence would this later lawsuit be if they could not substantively challenge the legality of what was happening?
Well, you see, that's
otherwise it's a tempest in a teapot over Rules 19 and Rule 24. It makes...
Doesn't it really say that if you could be adversely affected by a class action decree, stay out of court. Don't go in there.
Right.
Wait and challenge it later.
Wait and challenge it when it affects you directly.
To the employer, who might be inclined to sign the decree, but for the fact that some objector 10 years down the road is going to come forward. Are you going to tell your clients? Am I going to tell my clients? All right, when you sign that decree, you want to get some kind of indemnification that if you're going to abide by it. But if you're held liable for having abided by it, you want to be an indemnified defendant and held harmless.
That's the real danger, that it's going to discourage settlements
exactly right.
and consent decrees.
Can somebody refresh my recollection? Isn't there a Supreme Court case a few years ago that said you signed the consent decree, but you didn't get the union to agree to it, and therefore the union can bring a suit or an arbitration on it? So that, yes, it's very important when you're signing any kind of consent decree to be sure everybody's on board. But now let's assume we get everybody on board. And 6 years later, I hire somebody who says, hey, that decree is affecting me. Let's assume that we even have some kind of statute of limitations. Should that person be allowed then to bring a separate suit? We've got everybody on board who's there, but shall the unborn be able to bring it 10, 20 years later? What do you think, Judge?
Well, it seems to leave the door open to that. And maybe what one has to do when you're an employer or when you're a plaintiff in this litigation is bring in certain parties and seek to have defendant classes certified. Just as you have a plaintiff's class of persons who have been hired, persons who may be hired, etc., you may have to have defendants classes. I mean, it again is not reducing the litigation in the courts.
Well,
it may only be enhancing it.
Suppose it's not a consent decree. The plaintiffs bring a lawsuit. The employer fights as hard as he could. You go to trial and he loses. And as part of the decree, the federal judge says, even without a consent, I order 2 blacks and 1 woman for every 5 white firemen appointed. Then somebody new comes along 5 years from now saying, hey, I'm adversely affected. The rationale of Martin against Wilkes isn't restricted to consent decrees.
Yeah.
It just says no one not a party to the action is bound by it.
So they sue the judge. They don't sue the employer.
No, they sue the employer.
I think you're making far too much of this case. All this case says is you have an abstract right to bring a suit later on. It doesn't say that you are going to win that suit or that you have any kind of merit to your claim. And as a practical matter, neither the EEOC nor a private lawyer is going to be suing in federal court when there is no substantive cause of action. If the original consent decree complied with Weber and Johnson, if a court order complied with Local 23 and Paradise and so on, then I don't think that you're going to see later challenges because no decent lawyer is going to take that. There are Rule 11 sanctions for lawyers who do that.
If you do what Judge Patel is suggesting, add a defendant class, the unborn later, presumably whatever issue this later person could raise will have been dealt with up front by the defendant class. So it's very unlikely that someone is going to later challenge.
Except San Francisco police have already done it. I mean, so people are trying. They haven't reached our level of wisdom, I guess. And
the thing that's inexplicable about this case, however, is that there is a lengthy record in the court below. And indeed, that record reflects that the district judge conducted a trial. There were two sets of white firefighters that challenged their rights or the impact of the decree, and there were proceedings below. The district court reviewed the earlier decisions, the consent decree, the findings, and the basis for the decree, and presumably, in that case, had found Paradise, the necessary Paradise requirements, egregious discrimination, and so forth, and made a determination that those blacks who were promoted were qualified, and therefore that there were some substantive determinations by the court below. That seems to be ignored, and instead the Supreme Court focuses on the language of the district court about collateral estoppel and res judicata, and that is something I really don't understand.
Well, but the only question before the Supreme Court was the procedural hurdle question, and I think the reason for the remand is that the substantive issue is still there.
What about the statute of limitations? The Supreme Court, is your sense that the Supreme Court decided that you don't have that 180-day statute of limitations under the Lawrence versus AT&T, or they just didn't decide that question?
They didn't decide that question, but it is clear that the Lawrence discussion, from the Lawrence discussion, the court is distinguishing between a seniority system which is facially discriminatory, which can be challenged at any time, and a seniority system that is challenged because of its adoption and discrimination in its adoption that doesn't show up on the face of the seniority system. It seems as though the court is looking at consent decrees the same way. If it's a facially neutral consent decree, I think it's got to be challenged within 180 days, perhaps, after the consent decree, except to the extent that maybe seniority systems under 703H are the only area in which that rationale can be applied. But I think
so.
That's
unless there was unlawful animus at the time of the formation of the decree, you've got to challenge it within 180 days.
No. If the decree is facially preferential towards, say, blacks, then it can be challenged within 180 days of any adverse action taken pursuant to the decree. If the decree is neutral on its face as to race, then if Lawrence applies, even though we're not dealing with a seniority system, we're dealing with a consent decree, then it may be, as Peter, I think, is suggesting, that you have to bring that challenge to the consent decree.
And
if it hits you between the eyes, you don't have to do anything.
In this particular case, where race was affirmatively written into the decree, then the 180 days, 300 days kicks in every time a white is allegedly denied a position promotion as a result of the decree.
I think that's the way the court sees it.
Well, before we move on, thank you. General Counsel Shanor has to leave us at this point, but let's turn to Judy Vladeck to talk about, we've been through sex, and we've been through drugs, and we've been through the effects of time. Now let's go and talk about a little religion. There was at least one religious case in the Supreme Court, and let's see if we can get some religion here.
I couldn't figure out why this case was included for the panel today. It occurs to me that perhaps it was to show that even now with the new majority, there will be a liberal reading given to the First Amendment's guarantee of free exercise of religion, so that they're not again everything. Frazee was denied unemployment insurance benefits on the ground that he refused to accept work on Sunday. That would have required him to work on Sunday. And the state court upheld the administrative findings that he was not entitled to unemployment insurance because he was not a member of an established religious sect or church nor did he claim that his refusal to work resulted from a tenet, belief, or teaching of an established religious body. Nobody questioned his good faith. The Frazee decision is not new. It is simply an extension of prior decisions. What makes it different is that in the earlier decisions, Thomas, Hobby, and Sherbert, each of the plaintiffs was indeed a member of an established church or an established religion. Here, the Supreme Court, which was unanimous in this opinion, held that its judgment in those cases had rested on the fact that each of the claimants had a sincere belief in the religious requirement that he refrain from work, while the court said that only beliefs rooted in religion are protected by the Free Exercise Clause. It is not necessary that it be an established religion or a recognized religion. There is another interesting line in the opinion which raises questions as to what we might look forward to. The court says that there may exist state interests sufficiently compelling to override a legitimate claim to the free exercise of religion. That is just tossed into the hopper. I don't know why the court felt it necessary to predict that there might someday be such a balancing test. In any event, it seems that the court has gone as far as it can go in saying that if there is a sincere belief which has a religious quality, it is sufficient to be protected under the First Amendment, and the denial of unemployment insurance and presumably other similar benefits on the ground of the exercise of that religious belief would violate the First Amendment.
Do you think, Judy, that a sincere belief that I don't want to work on Saturday and Sunday because I want to watch the football games religiously is going to be sufficient to trigger the problems of reasonable accommodation under the TWA versus Thurston case, which says we have to make reasonable accommodation to the religious beliefs?
You better say that it is your creed or a tenet of your belief, rather than just say it is your personal preference.
Well, that's true, but let's assume someone says, I have a religion, and perhaps it's an organized religion that says I don't work on Saturday and Sunday. Those that I have to have 2 days off. How does that how do they get into the sincerity of belief in determining that we have to make reasonable accommodation to it?
I have to tell you, I think the way they get into it is very troublesome. There is a footnote in this case which I have difficulty understanding. They repeat a reference in one of their earlier cases, that is Thomas, where the court had said that an asserted belief might in fact be so bizarre, so clearly non-religious in motivation, as not to be entitled to protection under the Free Exercise Clause. They go on to say, but that doesn't apply in this case because, and I quote, as the discussion of the Illinois Appellate Court itself indicates, claims by Christians that their religion forbids Sunday work cannot be deemed bizarre or incredible. Well, I find that bizarre and incredible, but that is just a footnote. I would suggest that you really must, if you are making such a claim, be prepared to show that it is a way of life, that it is a dogma or a tenet which you have lived by, and that it has a religious quality, whether it's religion in the sense of reliance on a supreme being, as in some of the conscientious objector cases, or not, remains to be seen.
Well, you know, again, there are other doctrines that plug into it. Judy mentioned conscientious objection. There are prison religions, you know, where prisoners say, well, it's my religion, you know, to go out and walk outside the prison grounds every once in a while, you know. You know, or it's a religion that only I participate in. I'm sure you've had cases in California where prisoners have thought up every religion in the world.
You're suggesting that we are the country of bizarre religions.
Or vaccination. I have a religious objection to vaccination, which is recognized. Now, what the Supreme Court is saying is that practically anything is a religion if it, you know, has the place of religion. It gives you, as Justice Black said, no rest or peace unless you follow the dictates of that belief system. The real problem is sincerity. You know, how do you know that I sincerely believe in that in that religion? And I think that's what they were trying to get at Frazee. I mean, it wasn't bizarre. It wasn't a bizarre religious belief for someone who professes to be Christian to say, I don't work on Sunday. You do have a problem about sincerity, and how do employees, you know, look you in the eye and say you're sincere in this belief. But you know, whether someone is a religion and whether something is a religion and how sincere you have to be, we have bodies of law in these other areas that already require us to take a look at that.
I mean, I'm reminded of the group of kids in the Philadelphia high school who adopted a religion that gave them at least 2 days off on a Wednesday and Thursday every month, so that when they had to stay home. And the difficulty that the Board of Education and that everybody else had with deciding whether it was a real religion or whether their leg was being pulled. Have you found any of those cases in California?
I do think that there's a body of law, though, that does provide us guidance. The conscientious objector cases, the citizenship cases also, where someone seeks to be excused from performing work of national importance or military service, and has to prove the sincerity of their beliefs and that they're rooted in some religious bases. So the courts have been through this any number of times before. It's not an easy task by any means, but certainly there are some guidelines. And I would presume that the court is relying on those guidelines. I think this case is rather amusing, though, for other reasons, and really maybe tells us something about this country. It sort of seems to say that a little bit of religion is all right, but if we get too religious and it interferes with legitimate commercial concerns, then we want to be very careful about it. And for example, it's concerned about whether or not it will interfere with Sunday shopping or Sunday sporting, or for that matter, commercial interest will grind to a halt as a result of our decision. So if only a few people are religious, I guess it's okay. But if too many of us get religion on the same day, and it interferes with the commercial interest, then the court may have to take another look at it.
Well, that's of course what TWA versus Thurston says. You can have your religion, but if you can't get somebody to work for you on Sunday, when we have to have that flight attendant's job filled, then the employer doesn't have to make reasonable accommodation.
And 20 years ago, they wouldn't let you work on Sunday. I mean, that's the bizarre
So we see where our
thing.
priorities are now.
We have a couple of questions from the audience that I'd like to kind of tackle with the group now. First of all, someone has asked what is Congress doing about some of these cases, and I think that the fair thing to say is that there's a lot of activity, but nothing's been passed yet, so we don't know where it's going. Particularly from Senator Metzenbaum, there's a lot of activity. I think there's the FERA, the act that they're trying to overturn Ward's Cove and put the burden of proof someplace else. And one of the things that they're working on, even as we speak, is a bill to overrule the Betts case, which may make our discussion of it later academic. Another question asked, and I'd like to give it to Bob and Judith. What are plaintiffs' strategies to circumvent these latest cases, which clearly seem to make it much harder on plaintiffs?
Well, the central message to me as a plaintiff's lawyer is get out of federal court, get into state court. No matter what court I'm in, get me a jury. Use Hopkins as frequently as I can. Use footnote 5 in Hopkins, which talks about 703A2 and leaves open the question of whether you have the impermissible motive, but maybe it is not the determining, substantial, predominant, whatever it has to be, factor, but nonetheless it's there under 703A2, do you still prevail? Those are some of the lessons that I take away from these cases.
Judy, you have some tricks of the trade for us?
I can only tell you what I'm doing, which is to look a lot more carefully and cautiously at any class actions for blacks. I do not know. I think that the impact of these cases is going to be more serious in the area of racial discrimination and in the lower level jobs. I am more sanguine about being able to live with them for upper level, white executive level. I think these are, unfortunately, now these cases are targeted at the areas where the class actions have been the most useful device for overcoming systemic discrimination. And what I will probably be doing is encouraging young blacks to either form unions or to organize or to turn political.
Well, I suppose the unions' efforts to get legislative relief have probably hurt them because they've made them unnecessary in a lot of cases where the unions used to provide the service that they're now asking the federal courts to provide. We have a question here on, it isn't, it's a question from a professor, and it isn't really phrased this way. But what he's really asking is what's happening with summary judgments now in the light of these recent cases, most particularly a case we haven't talked about because there really wasn't a decision, the Westinghouse case, where the Supreme Court took certiorari on a summary judgment case on a reduction in force area, I believe. And then after the argument, a week later, Justice Scalia was a little vitriolic in the during the argument, and they dismissed the case as the certiorari as improvidently granted. Judge Patel, what's happening in summary judgment? Are you treating summary judgment differently?
I think everyone is treating summary judgment differently as a result of the Celotex trilogy of cases in every area, not just employment. But I think, of course, what's happening now, and as a result of the Supreme Court's decisions last term, we will see more summary judgment motions brought in employment cases. It had generally not been a fertile ground for it because of questions of intent and so forth. Now, I think that it's pretty clear that even where questions of intent abound, putting the plaintiff to the test of making a prima facie case before trial is encouraged by the gamut of cases coming down from the Supreme Court, the summary judgment cases and, of course, now the employment cases.
Are you granting the summary judgment motions more frequently now than you did then?
I've always used summary judgment quite effectively. I've not been reluctant to use it, but I think what we tend to see in California now are far more wrongful discharge, state-bound causes of action that come to us either as pendant claims or diversity claims, and that's where we tend to use it. I think it still is pretty hard to do in age discrimination cases, albeit that we do get some.
I'm just amazed at that statistic that he gave us, that 10 years ago there were 1,000 class action employment discrimination cases, and last year there were 45. I mean, it seems that's nationwide. That is such an amazing drop, even before these cases came down. And I guess it does show that plaintiffs, they're very difficult cases to begin with. They take an enormous amount of resource and time. And now the possibility of success are so dim. I would be amazed if you get 20 a year at this point. They really have to be.
I think the growth in litigation in this area has been in the age area. Very clearly, I think, because of the right to trial by jury, at the reluctance to grant summary judgment under those circumstances, and generally the age cases that come forth are those that come up in the context of reduction in force, so that although you don't have class actions, you might have numerous plaintiffs in a large workforce, and you have people who tend to be in the higher levels of salary levels of employment and have the resources to move forward because they think their careers have been adversely affected. They have 10, 15 more years they'd like to work. The recovery is likely to be good for them. That's where I think the growth has been. I think we see very, very, very few race discrimination cases, very, very few sex discrimination cases.
Isn't it possible that a law that's been on the books since 1964, Title VII, a law that's been on the books since 1967, the Age Discrimination in Employment Act, has had some of the effect that it was supposed to have, and that there is less discrimination than there was then, that we have as a society improved? I know I look around me all the time, and I look, for example, you talked about the accounting firms. 15 years ago, there were 2%, 3% of the accountants coming in were women. Today it's 50%. The law firms, 50% of the people coming in are women. Minorities are coming in much larger numbers. I think as a society we've done a tremendous amount to eliminate discrimination, and I think you've got to credit some of that to the decline of litigation.
Credit away from that, Peter. You can go practically anywhere in this country and see dramatic changing. I cut my teeth in Jackson, Mississippi, and every time I go back to Mississippi, I'm amazed at what I see. But I'm concerned that the message of these decisions is we can now rest on our laurels. And you look at the statistics, particularly for black youth in this country, and I think it's terrifying.
Well, I think it's terrifying that the education is not being given to a lot of people.
To what extent these laws can operate to the benefit of that problem.